Great. Well, right. Well, on to the next session. I mentioned that we were lucky enough to have representatives of three of the key regulators with us. Here we are. I'll introduce them in a moment. Just to talk about some of the implications of the new laws that are coming in and the approaches of their offices. And also, hopefully, there'll be enough time for you to raise questions of them directly as well. So let me do some introductions. We'll go from this side to this side. So on the end there, we have Toby Spanton. Toby's head of legal service for data privacy, the data privacy advice team at the ICO, focusing on external engagement with tech companies, ICO guidance, and legislative reform. Before he was at the ICO, he was at MasterCard, and before that, he was helping write aspects of the Data Protection Act. So if you've got any gripes about the Data Protection Act, speak to Toby. Nearest me, oh no, I said we go that way, we go across, right. Ronan in the middle there has been a member of the legal service at the Competition and Markets Authority, the CMA, since 2016. He's a senior legal director with responsibility for competition enforcement and the digital markets unit, which is exactly the right part of the organisation we want to hear from. And nearest me, we have John Heim. John Heim is Director of Policy Development in Online Safety at Ofcom, the UK's communications regulator. He oversaw the development and delivery of Ofcom's recent consultation on protecting people from illegal harms. If any of you are familiar with that, it's a very large piece of work. You've obviously been a very busy guy. John's been working in this area for a number of years and has been working in various departments in Ofcom for over 12 years now. So that's our lovely panel. Just to introduce the topic, some of which I've mentioned already, that it sort of felt like the tech sector got off a little bit lightly in terms of regulation for a number of years. I mentioned competition law. We had it, yes, we did. We had data protection law, but it was kind of light touch, not lots of enforcement. Same with e-commerce. And then when we had GDPR come along, we saw competition level fines, big, turnover-based fines available for the first time in a very widespread way. And we also saw that the regulator was very prepared to use them. So that everything felt a little bit more serious at that point. Then what we've also seen is that although we've all been talking about the AI Act, prior to that, we saw GDPR being used almost as a proxy for AI regulation because it was all there was and it had so much to say about the way that data is used to train algorithms and that kind of thing. And then I'd also say that when we saw the age-appropriate design code come in, the children's code about how data about children should be handled, we saw the sort of introduction or amplification of the idea of the best interests of the child, which strayed more into a sort of wider harms and content issues and maybe online safety stuff to a certain extent. So it sort of felt like we've been getting a little bit more regulatory for a while, but now a lot has changed. We have the Online Safety Act, which John is going to talk to us about. We also have the Digital Markets Competitions and Consumer Act, which Ronan's going to talk to us about. And of course, we still have GDPR and the AADC, which Toby is going to talk to us about. So the idea of this session is not to put up loads of slides about each of these laws and kind of grind our way through them, but to ask our regulators here to share with you what they can about the priorities of their office, what they're expecting to see from industry, what good looks like, maybe what bad looks like, and so on. And then we'll get into a conversation around how they cooperate, because we've got regulators all sort of looking at the same issues to some extent. So I thought we'd kick off with Toby, and just perhaps in your own words, just to tell us what's the ICO up to when it comes to technology.
I'm just going to talk about the three ICO priorities which we're focusing on this year and next year. And I suppose the reason to focus on these are the ones where the ICO will be paying our most regulatory scrutiny. So for you and your organizations, these are the areas where, frankly, the ICO will be prioritizing our sort of interest and focus. Of the three areas, there's AI, which is perhaps unsurprising. Online tracking continues to be a focus, and children's privacy is like a big passion of the current commissioner as well. So kicking off with AI, I'm sort of conscious that I think maybe the last time was Tech Summit in 2022, November 2022. OpenAI just released ChatGPT 2 years ago. A lot has happened in 2 years. They reached 100 million users in 3 months. And I think regulators around the world and governments suddenly woke up to AI. In the ICA, we felt a little bit smug because we've got a technology neutral legal framework. The GDPR and Data Protection Act are kind of applicable to the processing and actually quite easy to apply in some contexts and quite challenging to apply in other ways. So the ICO were quite quick off the mark here, and we started issuing AI specific guidance in, I think, April 2023. And that was sort of fairly well received. It was applying the DPNet framework to the new AI sort of challenges. And then this year, and I think some of you in this room probably responded to the generative AI consultation that the ICO has been conducting. And that's been looking at some of the particular challenges around developing these large language models, and particularly around accountability. So who's responsible for the data processing that's undertaken, lawful basis, data subject rights. So that consultation recently closed. So apologies if you didn't respond, but we had hundreds of responses from a range of small tech firms, large tech companies, NGOs, and we're going to be publishing a consultation response later this year, so in December, and that will help offer sort of a more final outlook about the ICO's views about regulatory compliance in the context of large language models. And then in AI, it's not just guidance. We are taking action. So one example is with Snapchat, their My AI chatbot. The ICO issued a preliminary enforcement notice around whether or not they completed their data protection impact assessment accurately or fully. And I think that's a really good example here around DPIAs, or often seen as a bit of a tick boxing exercise. They can be quite dull, but in AI, they're a hot issue. It's around really identifying those risks and evidencing that you've mitigated those risks. And that was one of the big focuses in the Snapchat notice. And then sort of a less formal regulatory action we've taken in AI. You may have seen statements over the last few months from both Meta and LinkedIn, who both put a pause to processing or proposed processing in order to specifically engage with the ICO. And that's because companies are increasingly waking up that, build compliance in from the start. And they are both sort of have different plans to use their own users' data to generate AI models and put a pause to some of that in order to ensure compliance. So just moving on to online tracking very briefly. So we had last year, the ICA's focus has been on ad tech. Last Christmas, I think about the top 100 UK websites the ICO looked at. Early Christmas present, we had flagged issues with compliance around cookies. So the thing that we all just accept when we open the web page to get rid of them. But a lot of websites were not presenting user choice screens correctly. Out of the 100 UK top websites, 53 had compliance problems. We wrote to them and 52 of them have already made changes. So it's an example of the ICA's compliance not just being about issuing fines, it's about sort of nudging people into the correct compliance zone. But it's not just stroppy letters from the ICA. We are also we really want to support innovation. So currently we've got Meta in the ICA regulatory sandbox. They are working on new privacy enhancing technologies, which should sort of help with ad measurement, so alternatives to cookies. And that's something, so they came into the sandbox a couple of months ago. It takes about 6 to 12 months. And the idea is at the end of that, we should have something to share with the world on our website, which will show what Meta we're proposing and the ICA's response to it. And then finally, just on children's privacy. So Mark made reference to the age-appropriate design code, which we launched in 2021. It's one of the ICA's proud moments because lots of other jurisdictions have kind of been inspired by it, copied it. Certainly US states and legislators have been looking at the ICO code. The enforcement around it's been, I suppose, there's been sort of less formal stuff. So we've seen a lot of big platforms, Meta, Google and others, introduce some changes to their services. So, for example, changing the way in which ads are served to under 18s, introducing sort of features such as take a break features so that children are sort of prompted to take breaks. But there's also been enforcement action. So TikTok, the ICO imposed a fine of almost 13 million on TikTok And that's sort of wider compliance issues, but there was also a focus there about whether or not TikTok are processing children's data lawfully. And so that case is still working its way through the courts, and we sort of look forward to seeing where that comes and get more regulatory certainty. But yeah, that's sort of a highlight of our current priorities, I think.
I'm smiling because obviously it's a case where we're on opposite sides of that. So I didn't know where you were going to go with that. So I leave it. The one follow-up I wanted to ask you about was the pauses when you approach Meta or LinkedIn and say, hey, we've heard about this thing you're doing, training algorithms. Is it, and let's maybe move it away from those two specifically, if you hear about something being launched like that, would you pause because you've got concerns from what you can see from the outside, it looks maybe a bit non-compliant and you need to know more? Or is it more, oh, it's new, we haven't heard anything about it, we better have a look anyway just in case, so please pause to give us more time? So is it concern driven, or is it we just got to get our hands around these new things?
I think it's a combination. I mean, I should say actually, in fairness to all of these companies, that generally they're approaching us. So we're not normally waiting to reach out to them. It's less the ICO reading about concerns, both Meta and LinkedIn for those cases.
They'd have a formal liaison
Yeah.
with your office, right, and account management and so on. So
Exactly.
for those specifically.
But yeah, we have like most of the large tech companies and small tech companies, and the ICO. There's lots of routes into us. So again, a bit of a sales pitch. But if you're developing an innovative AI, there's loads of ways to come and approach the ICO and have those discussions. And there really is a sense of like wanting to support innovation and find out about the problems. So yeah, not prejudging any of it.
And we're all going to plug the digital AI and digital hub later, right? So we will come to that. Fantastic. Before we move on to Ronan, can I just say for the record that when we were planning this event and they say, what do you want the layout to be? At no point did I say, well, put me on a stage, standing up, and put the regulators down off the stage, sitting down, so I tower above them. That is unfortunately just the way the building worked out here, so I apologise, chaps. But now moving on to Ronan and what the CMA is up to. Now, obviously, you've got a whole new law to obviously you'll get to grips with, but industry has to get to grips with as well. So perhaps you can tell us a bit about the DMCC and what it means and what companies in this room might be thinking about or should be thinking about.
Sure. This is on, is it?
Can everybody hear Ronan?
Maybe that's better. Anyway, hopefully you can hear me. So for those in the room who are familiar with the CMA, great. For those who might be less familiar, obviously beyond tech, we're the regulator for competition and consumer law kind of across sectors. But it's not our first rodeo in terms of tech. Whenever we come around and look at the DMCC Act, which, as Mark says, we'll get on to, we have obviously spent a lot of time over recent years in the general tech sector, both across Competition Act cases, commitments from Amazon and Meta in terms of how they use their platforms. We've obviously looked at it in the mergers context, and we have a number of significant markets pieces of work, which we've both worked through, and a few which, for example, in the cloud sector are ongoing. But whenever it comes to the DMCC Act, this is an exciting new piece of legislation, which has now been passed, and we're awaiting commencement as expected early next year. And what it effectively does is give a new suite of ex-ante tools to the CMA to ensure effective competition on digital markets. Now, it's I'll give you a very whistle-stop tour of it, right? Because it's long and complex, and I don't want to bore everyone, and there's no end of written material out there if you want to get into it. We have set out our guidance for consultation earlier this year. That consultation period is now closed, and that guidance is awaiting final sign-off, but expected to be effectively in situ for the commencement of the regime, as I say, early 25. And thank you for everybody, maybe many in this audience, who responded to that consultation. But under the DMCC Act, what we're looking at is effectively new terminology around what we call digital activities. And to the extent that a company or firm is involved in a digital activity and is considered, once we've assessed that digital activity, to hold what's called SMS or strategic market status in that activity, we are enabled to put in place for that firm, with respect to that digital activity, a number of requirements, which are called conduct requirements. And these conduct requirements are, as it says on the tin, intended to direct the conduct of the firm, to hopefully mitigate any competition concerns which might arise from that digital activity and from the strategic market status that the firm has. So beyond the conduct requirements, this is all going to take place. The SMS investigation, say day one, I don't know, I'm making this up, 1st of February. You then kind of fast forward, that investigation would take 9 months, at the end of which we would come out with a decision as to whether or not the firm has indeed got SMS status, at which point that is the gateway that allows us to put in place these conduct requirements. These are kind of prescribed in the legislation, the kind of things that we can put in place. And beyond that, we can open a separate investigation, which is called a PCI, or a pro-competitive intervention, which then kickstarts another 9-month period, which is more in depth. It'll take longer, and it's intended through the PCI to address more of the core market concepts, which is driving maybe the market problem in the first place. So through this new ex-ante regime, we are, and I'm sure we'll get onto it later on in terms of how we're engaging with companies, kind of becoming more attuned, because of course, traditionally, we are in the digital space, I say, kind of quite often looking back. And we're enforcing under the Competition Act or whatever. Here, we're looking as a regulator at an ex-ante level towards a participative model with firms to make sure that in these highly complex markets, we are properly understanding and properly curating the proposals and the outcomes that we're putting out. And on the flip side of that, of course, for any good participative model, you do need an effective enforcement model to, where needed, effectively make sure that what's required is indeed lived up to. So there are, within the DMCC Act, also quite a lot of mechanisms by which, if firms do not comply with these conduct requirements or the outcomes of the pro-competitive interventions, then quite stringent enforcement mechanisms which will be used, and with significant fines at the end of it all. So that's a whistle-stop tour of the DMCC Act. I hope that wasn't too technical, and there might be some more kind of pragmatic follow-on questions which come from it, but hopefully that'll give you a framework for what's happening.
That is great. Thank you, Ronan. It's as I've understood it, the UK approach is for a company that's got SMS, there will be this quite curated, bespoke set of conduct requirements, which contrasts with the European approach, which is a bit more, if you're a gatekeeper, here's a bunch of rules that apply to everybody. So it feels like the UK approach is a bit more flexible maybe and a bit more tailored to the particular company. Would you agree with that?
I think right? Tailored is the right term to use. So for those, I'm sure many of you are familiar with the DMA, but under the DMA, which is the EU equivalent to the DMU regime, effectively you have gatekeeper companies or platforms, which once you're actually considered a gatekeeper company, kicks into place a number of predetermined requirements. Whereas under our regime, it's been decided that effectively, once again, let's call SMS status that similar gateway into the requirements. But at that point, the requirements will be curated around the firm. Now, there are pluses and minuses to this, right? So on the one hand, with a more kind of straightforward menu of things that you know you got to put in place, it's very simple. It's very straightforward. There's very little kind of scope for debate, and it's probably making for a more timious outcome. The CMA outcome, obviously, as we say, a much more kind of, at least it has the opportunity to be much more tailored to the market issue that's at hand.
Great. One other question that we've heard that seems to be kicking around is that traditionally, I suppose, and I should say I'm not a competition lawyer, just in case I will now disclose that to everybody. It will become very obvious. But traditionally, one would think about dominance, and when you're talking about behavioral sort of issues like this, and to determine dominance, you think about market share, and to think about market share, you think about, well, what's the market? The sense one's getting from the DMCC is that there's not as strict a market test approach for a dominant. The question of dominance doesn't feature. It's a slightly different terminology. I think we're talking about substantial and entrenched market power. Can you elaborate a little bit on how that might work?
Yeah, of course. So there's been quite a lot of commentary around this, maybe in the slightly more pointy-headed competition law press. But Of course, dominance is a creature of a few things. It's a creature of the Competition Act. That's what the point of Chapter 2 under the Competition Act is, abuse of dominance. And that in turn is a creature of Article 102 of the treaty, which similarly deals with dominance. Here, this is quite deliberately a new legal framework that we're dealing with. And whilst many of the things that we're talking about whenever we talk about dominant positions and whether or not the special requirements for dominant firms kick in from a competition law perspective will be similar to the things that we're talking about whenever we're considering whether a firm has strategic market status, such as, for example, the level of alternatives that users have, the barriers to entry for that market, the pricing history for that product. These kinds of things are similar factors which will play into an assessment of SMS for the purposes of DMCC. It is distinct, and it's deliberately designed to not be within the confines of a largely retrospective dominant assessment, but rather with a view to an ex-ante regulation which looks forward to a 5-year period, following from the SAS designation, which makes it, I guess, less appropriate to retrofit all of the features of dominance into that. But as I say, it's not to shy away from the fact that both of these assessments are looking at market power in some way. And it's many of the factors will cross over.
Fantastic, thank you. Right, let's move on to John from Ofcom. Ofcom obviously, like the CMA, are dealing with the introduction of a new, a really significant piece of legislation. So, John, there's been a lot of guidance out there and codes and a long timeline for implementation. So, perhaps you'd like to talk us through what's coming in the next few months.
Absolutely. That is working, is it?
Yeah,
sounds like it.
So.
Okay, yeah, so thanks, Mark, and thanks for the invitation to be here today. It's a really exciting panel to be on. So I was going to say a couple of words about what the Online Safety Act is, what the Online Safety Act does, what our timelines for implementing it are, and then I was going to say a few words about our priorities as the rubber hits the road with implementation. So effectively, the Online Safety Act is a new piece of legislation. It gives internet services, so online platforms which enable the sharing of user-generated content, and search engines duties to assess the risks of illegal content being disseminated on their services, and to take steps to mitigate the risks they identify in their risk assessment. It also gives duties to services that enable the sharing of user-generated content and search engines to protect children from certain types of harmful content, such as pro-suicide content, self-harm and eating disorder content, and pornography. I think the thing I'd stress at the outset is that in contrast to what Ofcom does in the broadcasting space, our remit under the Online Safety Act is not content regulation. So the Online Safety Act does not give us sort of powers or a mandate to give platforms instructions to take down individual bits of content. That's not what it's about. Rather, our focus is very squarely on systems and processes and ensuring that platforms are doing a good risk assessment and putting in place systems and processes to mitigate the risks they identify. So that's really the focus of the Act. In terms of our process for mobilizing the new regulations, so we are sort of setting up the legal framework in 3 broad phases, so which overlap with one another. So the first phase of the process of implementing the Online Safety Act is all about illegal harms. So in that first phase of work, we are consulting on the sort of codes of practice and guidance, setting out what platforms need to do to protect people from risks of illegal content circulating on their services. We kick that first phase of our mobilization of the new regulatory regime off last November by publishing a consultation on our codes of practice and guidance in respect of illegal harms online. The second phase of our work to mobilise the new regime relates to the duties around protection of children. So there we consulted on draft codes of practice and draft guidance, setting out how platforms should assess and mitigate risks to children in May of this year. So that's sort of second phase. And then the third phase will relate to some additional duties on some of the largest platforms, to set clear and consistent terms and conditions, and to take action in respect of fraudulent advertising, and also to be more transparent. So there are some additional duties on the biggest platforms. We'll start our work in earnest to mobilise those additional duties next year. In terms of sort of where we are now, that first phase of mobilising the regime that I mentioned, the work in respect of illegal content, that will really conclude at the end of this year. So we, as I mentioned, we published a consultation last November. That closed at the end of February. We had a hell of a lot of responses, so we've been spending a long time working out what we make of them. We anticipate publishing a regulatory statement at the end of this year, basically finalising our codes of practice and guidance on illegal harms. And then the rubber will kind of hit the road. So when we finalise our codes and our guidance, platforms will then have 3 months to do a risk assessment, assessing risks of illegal harms on their services. And when they've completed that risk assessment, they'll need to start putting in place mitigations for the risks they identify. And as the rubber hits the road, what we're really looking for are 4 things. So firstly, we want, and these very much align with the sort of core purpose of the Act. So our first sort of big strategic objective is around governance and risk assessment. So we want platforms to do a really high quality risk assessment, and we want them to have, really strong governance around that risk assessment. So reporting online safety risks up to, sort of most senior governance bodies in their organizations. Secondly, we want services to be designed with safety in mind. And that's really all about putting in place the systems and processes to mitigate risks. So that could be, using AI to detect harmful content like child sexual abuse content. It could be having adequately resourced and trained content moderation teams to detect and take down harmful content. It could be having good reporting and complaints mechanisms so users can flag illegal content easily. Our third sort of strategic objective is around choice, and that really boils down to we want platforms to give users tools to protect themselves from harms online. And our final strategic objective is around transparency. I think in our view, there's not enough transparency in the sector, in the tech sector, about what firms are doing to protect people from harms. And we want to change that, remedy that transparency deficit. So those are sort of our objectives. And the final thing I'd say, really what all this boils down to is what we want to see as a culture shift to a culture where, tech firms are sort of treating safety as front and center when they're designing their products. And are trying to make their products safe by design, for want of a better word.
Safety by design, that's great. Thank you, John. Just a couple of follow-ups. One is probably the question we get asked the most when it comes to anything involving children online, and that's about age assurance. So the view, and I don't mean Ofcom's view, but just the view seems to be from most regulators that if you have an identification standard where you require passport from a child or a parent or to establish their age with a great level of certainty, it's disproportionate, it's too much. Obviously, the platforms wouldn't like that either because it'd be too much friction. So we hear passports too much. We also hear then the alternative of putting your date of birth, so a neutral age gate, let's say, possibly too little. And there's a magic solution in the middle that could be some technology solution, but it doesn't feel like a market practice has yet evolved or hardened into something where everybody really understands what best practice looks like. So obviously, your office is going to have to be thinking about age assurance. I just wondered, not what the answer is, but where things are heading on that, if you can say so.
So we've published a couple of consultations on this, and broadly speaking, what we've set out is that where platforms have children on them and they allow content which is harmful to children, they should put in place highly effective age assurance so that they can sort of curate children's user experience so they're not exposed to that content. And, you know, if you're operating a pornography platform, then similarly, you should put highly effective age assurance in place and age gate it from children. We've taken a principles-based approach to setting out what highly effective age assurance is, because I think, you know, there are age assurance technologies out there, but the market's quite nascent, and we thought it could be counterproductive to be too prescriptive at this point in time whilst the technology is evolving. So we allow that sort of principles-based guidance, allows for a range of possible solutions. What we're very clear on is we think self-declaration of age is, you know, clearly insufficient. Because kids, you know, as we all know, will lie about their age when they want to access certain platforms. And we've been working closely with the ICO actually to ensure that our guidance on highly effective age assurance is sort of compatible with data protection and privacy law, because there's clearly an intersection between our regulatory perimeters there.
Great, thank you. Right, I just want to move us on a little bit now to the section on my notes I've just called carrot or stick. So I don't know who's going to go first, but this was, here we have 3 regulators whose offices individually put out a lot of guidance, are also very accessible and happy to liaise with companies and to open lots of channels for cooperation. But we also have them supported by laws that have some very, very significant enforcement powers, from whether it's 4% or even up to 20% in some situations of global turnover. So just help us, if you can, in thinking about, you both use carrot, you both use stick. What's the mix, and what are the sort of factors maybe that operate when you're deciding what to do?
I'm happy to go. Yeah, I mean, I suppose I've already spoken a little bit about the range of different regulatory actions the ICO has taken even the past 12 months. I think that really does reflect the mix. I mean, generally, you know, we are wanting to support compliance. We don't go straight to stick. We've got the ability to fine, like Mark says, rather large fines, but that tends to be not quite a last resort. But we are working in conjunction with companies. I mean, just to flag, because again, it may be of interest to this audience. Early next year, we're going to be consulting on a new procedural guidance, which will provide, hopefully, a lot more insight into how the ICO approach investigations, what's the trigger for enforcement action, because I think what we're wanting to move to is like a total no surprises approach. And, you know, we want to provide that transparency about what the triggers are in the ICO, because we know there's sometimes commentary. Why is the ICO issued a reprimand here, a fine here, or just engaged with industry here? So yeah, that document will be going out for consultation early next year, which should also more closely align us with the CMA and Ofcom, who I think both have sort of similar documents in existence. We're a little bit behind the curve, but we're going to be providing that early next year.
Fantastic, thank you. John, Ronan?
Shall I go ahead?
Yeah.
So I think this carrot and stick conversation, right, can sometimes be characterized as opposing, right? Whereas in fact, I think I look at it, is that they're effectively driven towards the same outcome, which is to ensure that there are effective, appropriate outcomes put in place. So the participative model, which is what we might call the carrot, is completely designed within the ex-ante regime to make sure that we're not making mistakes in incredibly complex markets, that parties are engaging with us proactively to make sure that what is put in place is effective and consultations are properly run, and with a view to actually having effective outcomes at the end of the day. Now that takes you so far, right? And that is a really important part of the jigsaw to make sure that you do end up with effective outcomes. But there is a, I think, completely consistent approach which comes your way whenever you talk about the stick. And that in order to make sure that those consistent outcomes are once from a participative model put in place, they're actually seeing through, then it is important, I think, to have the enforcement model to make sure that there are proper enforcement tools in place to deliver those same things which the participative model was designed to capture.
Okay, great. John, anything you want to?
I mean, I very much echo what Toby and Roland said. I mean, I think, you know, in short, to your question, our preference is to use the carrot, but we'll use the stick if we have to. And we've got a reasonable size stick, you know, if you look at the enforcement powers we have. And to sort of unpack that a bit, you know, we have a big supervision team who liaise regularly with the largest and riskiest services. You know, we try via informal engagement to bring people into compliance. But where that fails and where people aren't willing to work with us, you know, we're very willing and ready to use our enforcement toolkit.
Very good, thank you. Right, so we have three regulators, all looking at the tech sector with new laws and expanding mandates, and also the possibility of overlap. So just to take a simple example, you could have a data protection breach or issue that would be squarely on the ICO's desk, but equally for a company with whether it's dominant or however we describe it, that could also contribute to abusive behaviour potentially if they breach data protection. And we have seen that in other countries. So the question really, or this bit, I'd like us to get into cooperation, regulatory alignment, and how you all not exactly stay in your swim lanes, but kind of do it in a coordinated way. And I was just going to mention the Digital Regulation Cooperation Forum, the DRCF, which has been around since 2020, which each of your organizations is represented on. So this was a sort of non-statutory body set up kind of voluntarily in some ways to have the regulators cooperating with each other and coordinating this complex area where there's lots of potentially overlapping issues. So it'd be good to hear a little bit about how that works in practice. I'll probably roll on to the Google Sandbox thing if we have time to get onto that. And if you want to plug the Digital Hub, then go for it, because that would be good to hear about as well. So again, whoever, Ronan, do you want to?
Yeah, quite happy to. So, and this is the great thing about this kind of a setting, where it does kind of bring into focus the cross-regulatory aspect of a number of the issues, which I'm sure a lot of you and your companies and your clients are dealing with on a day-to-day basis. So in particular in the digital sector, for example, working with the ICO, working with Ofcom, dealing with competition issues through ourselves, or indeed with issues which might touch upon the remit of the Financial Conduct Authority. There is, as Mark noted, a forum that has been set up with these challenges in mind to make sure that there is at least a place for us to effectively discuss these things, and that's called the DRCF. The DRCF is it's still quite a reasonably nascent thing. What we have, as Mark said, set up over the last maybe half year, we're in the middle of effectively a test run for what we call the DRCF AI Hub, which is specifically designed with this kind of thing in mind, where you have in particular small innovative products coming through from a digital perspective, which might have lots of regulatory questions arising, which might, depending on how a company feels about those regulatory issues, impede or promote their bringing to market of a product. There's actually a forum within which those queries can be put forward so that the regulators on a cross-regulatory basis can put forward what is, in fairness, a non-binding opinion, but effectively give a steer on what issues that smaller company with an innovative product might be well advised to bear in mind whenever they're thinking about the cross-regulatory issues at hand. So that, as I say, deals with Toby's world from the ICO, with John's world, with my own, and it can hopefully bring together those things into one piece of consolidated views.
Okay, John, do you want to go next?
I mean, yeah, I think what I'd add, so where I've really seen the sort of rubber hit the road, so to speak, with the sort of regulatory cooperation that the DRCF facilitates, is in the work I've been doing on the Online Safety Act. So there are a range of issues there which in particular intersect with the ICO's remit. And I think actually sort of through the auspices of the DRCF, we've had some really great engagement. I think where we've had proposals, and there've been a number of them on things like age assurance, content moderation technologies, etc., that have implications for privacy rights. We've had a really rich dialogue with the ICO. There've been a number of instances I can think of where we've sort of tweaked our proposals, tweaked our codes, etc., to reflect feedback from the ICO. So, I mean, I guess my reflection is that's where I've really seen this regulatory cooperation coming to life. I think it's proved useful. I think it's proved effective, and I think it adds to the quality of our work.
That's great. Toby, before you offer some thoughts on that, I was just going to set out the sandbox piece. You don't need to talk about it specifically, but just to sort of bring this cooperation to life. So, and again, this involves Google, but I'm not going to talk specifically about the kind of merits of it or anything like that, but more, I'm just interested in how it worked in practice. So we, for privacy reasons, had a proposal a few years ago now from Google to change the Chrome browser so it didn't accept third-party cookies. So this is sort of other browsers do it. It's kind of an ad industry response. It's focused on online tracking, if you like. And so that was, various technologies were proposed to accommodate that. All, on the one hand, kind of good news from a privacy point of view, one might think. But of course, Google is itself very heavily involved in the advertising space, and any changes it makes in relation to its handling of third-party cookies could potentially raise competition concerns in terms of its place in the ecosystem and what it means for other publishers, what it means for advertisers, and so on. So it started out as, putting it very, very too simply perhaps, as solving a privacy problem creates a competition problem, maybe. And so I know it was on the desk of the DRCF, and still is, I imagine, but just in terms of how the offices work together, and forgive me, Toby, if you weren't involved on that directly, then, but please, how did that work?
Yeah, I mean, my team's been working very closely with CMA for quite a while now. I think I can't quite remember when it all started, but it's been great. Like you say, there's been sometimes an idea that there's sort of a tension between competition and privacy, and we've sort of keen to avoid it. And I was sort of reminding myself of CMA and the ICO have got this joint statement, and one part of it is around how actually competition can help to ensure that data subjects have better control over their data. So it's seeing those sort of synergies, and I think the CMA and ICO have very specific roles in the Google Privacy Sandbox process, and we sort of lend our own expertise to it. But I think it's been very collaborative. It's been quite an intense process at times, both because it is a formal process, unlike some of our more informal, like the AI sandbox that the DRCF is running. This is a sort of formal process, which an end is a very formal end is needed, as it were. But so it's quite different in nature to some of the more relaxed format, which we are with some of the engagement, as it were. But I'm not sure if you've got anything to add, Ronan.
Nothing huge, to be honest, but I agree that it's a very good example of this kind of issue, which I'm sure we're going to see many more of in the digital space, and why it's so important, as I say, to have this kind of cross-regulatory approach to things, where, yes, albeit that the privacy and the competition outcomes are entirely consistent, they do, depending on where you're coming out on a particular scenario, impact one another. And the importance of kind of working together to make sure that there is a consistent, well thought through outcome has, I think, kind of borne quite a lot of fruit through the process, which is ongoing, on this cookies issue.
Fantastic, thank you. So I had one more question, but I'm also conscious of time. And so I think what I'll do is I will ask if anyone in the audience have questions. And if you do, we'll take your questions. And if you don't, we'll take my question. So please, and I think you've got a microphone with a button you might be able to push, and I'll repeat the question so everybody can hear it. Does that work? Not sure it is, but just go for it. I'll be able to.
It relates to the Google cookie situation, but more potentially from the ICO side with the programmatic networks and the data that's exchanged publicly there. What's the status of that investigation at the moment? Is that still ongoing as well?
Sorry, which investigation?
So the IAB's work with
Oh.
the public auctions within the programmatic.
Yeah, I mean, so as I said, I think the ICO is definitely exploring. So I think there's more work going on around how privacy enhancing techniques can be used in the ad tracking world, and there is a plan, I think, for. I don't think I'm saying anything I shouldn't. There's more guidance coming out in due course on, and that's what one of the things we're working with Meta on in the sandbox, the ICA sandbox currently, is looking around how that process can work. But yeah, I mean, there's nothing to announce on the ICO's thinking on that at the moment. We're sort of still looking into it.
Is the ICO busy on pay or OK at the moment? It is, right?
Yeah, I think in common with the DPAs in Europe, with the other data protection authorities and the EDPB, the ICA is currently looking at consent or pay. Obviously, the high-profile example of that, a Meta adopting that model in Europe, but they're far from the only player looking at that as an alternative sort of way, and so there will be again later this year. That's a very vague timeline on when the ICA will be providing some thinking on consent or pay. And I think I should just say there's sort of an overarching theme here of whether or not the ICO is and UK regulators generally, whether there's any divergence away from what the EU are doing. I think it's too soon to tell how stark a divergence there is, and often they're slightly over-egged when there's differences, and slight differences in opinion get looked at and a lot of scrutiny on it. But yeah.
Fantastic, thank you. Any other questions for the panel? No, well, we're bang on time. Why don't we just do concluding remarks, if that's okay? Just whatever you want to say, like a half a minute or something, just to leave them with a good feeling, or however you want to do it. John, do you want to kick off?
Sure. I think my concluding thought will be this is the big year for online regulation. With the Online Safety Act coming into force and with the DMCC coming down the track, I think we're going to see a sea change, and we're going to see the big tech held to account.
So from my perspective, I guess what I would like people to take away is the importance of engaging with the regulator, right? We call it this participative model, and we have this kind of bogeyman of a stick. People are genuinely very kind of concerned about raising issues and, kind of showing their hand at a regulatory level. But I'm not entirely sure that that's where effectively history points us to being the best approach. And that the regulators, I think, across the piece, speaking for the CMA, but I'm sure also for the other regulators on the stage, are very open to engaging, in particular in a regulatory perspective, with those companies, with the view of ensuring not a heavy-handed approach on anything, but to making sure that things are effectively dealt with as constructively as possible.
Great, thank you. Toby, final word to you.
Yeah, sure. I mean, I'd agree with everything Rony just said about engaging. I mean, one of my notes I put down here is don't ignore the compliance, don't ignore the need to engage with the regulator, because I think we've shown that actually engaging early on is the way to sort of avoid some of the headaches that some companies find. And I mean, just to say, keep an eye out for other reforms. We certainly will be. I know in the next couple of weeks there's going to be a new bill around data, reforming the DPA and GDPR. That's come back from the previous government, and there's also some AI reforms in the future. So we will be keeping a close eye on it, and I'm sure you all will as well. But
fantastic, thank you. Well, we're going to go into a tea break now, but before we do, if you join me in thanking our panelists, please.